Okay, folks, good morning. Can you hear me okay? Am I coming through? Can you hear me? Yes? No? Yes? We're okay. Okay, good. Good morning. I'm Jeff Whitman. Welcome. Thanks for coming to our Deadly Sins presentation. This is David Martindale to my left, Timothy Tippins to my far left, and we're looking forward to being with you here for a while.
On the far left.
Just to,
That's a first.
yeah, it's the first time he's ever been told he's on the far left.
Of anyone.
Yeah. Just to get a sense of who we have here, how many people have a primary professional identification as in ADR, mediation, collaborative law, that kind of thing? How many have a primary professional identification as a mental health professional? And how many have a primary professional identification as a lawyer, a judge? Okay, great. So it's a good mixed group. I'm going to ask you to hold questions until the end. We'll give you time to fire some questions at us. When we spoke about this ahead of time, I said to my co-presenters that I thought it was very important for us to we had to get the right tone for this presentation, because when you're talking about the errors that evaluators make and peer review and things like that, it can be a bit of a sensitive topic. So getting the right tone was I think very important. So this is the day that we were ordained. I'm looking a little bit like the Holy Ghost there. It was a nice day. We get done in the cathedral. We come outside, and obviously, no surprise, Tim immediately demands the big bishop hat. So we said, "All right, you can get the big bishop hat." This is also around the time that a lot of you have a copy of this. David's new book came out. The top 500 grammatical errors that God made in the Bible. And it was a wild success. So, anyways, so what you can expect in the next hour and a half or so is the following. We're going to present a general model for kind of evaluating evaluations, very briefly, just to give you a rubric. And then we're each going to list some of the top sins we've seen over time evaluators commit as they do custody assessments and deliver their reports to the court. I will freely raise my hand as somebody who has made more than one error, many more than one error in my own career. So I approach this topic with as much humility as I can garner, because in the end, this is a human judgment process. By definition, there are going to be, in the fancy term, there's going to be error variance to a greater or lesser degree in an assessment. But I think you'll see in the sins that we have selected that every one of these is absolutely, entirely avoidable, and it is embarrassment to our profession that they have even ended up before any court of law. Now, the first thing I want to talk a little bit about is the custody assessment analysis system, the CAS system. This is just a general model for us to use for the morning. This was published by Matlaw last year, and it's a model in which I tried to map the approach I have developed over time to doing peer review or work product reviews, is probably the more contemporary name at this point. But it's also grounded, the model is grounded in the best parameters and guidelines we have from our field and in the clinical judgment literature. Now, just a note, WPR, work product review, a note about work product reviews. They are not about humiliation, okay? Although sometimes it can feel that way. A peer review is really, in a sense, about ensuring that a court is getting information before it that can be viewed as sufficiently reliable to be used in a setting that is going to redirect the trajectory of one or more of the parties' lives, either one of the litigants or the child's life. So what is the CAS model? Basically, it was designed primarily for attorneys, although it's very useful in terms of kind of reminding ourselves of the most important principles of custody assessment. It's a model for attorneys to be able to use when they have to do their own pretrial assessment. They don't have the resources or an interest in having consultants come on board. And as I said, it is grounded in the clinical judgment literature. General sense of the structure, it basically has 4 major dimensions. Those are the things we're going to use this morning, and I'll talk about them in a minute. There are 112 deficiency components, or ways that we go wrong. And these range from the teeny tiny, no big deal, to the, if you've only got one of them, it's an entirely unreliable report. Okay, so there's a whole range, and we're not going to go through them now, but just to get a sense of the size of the model. The mirror model in the CAS approach basically takes every one of those 112 deficiency components and flips it and gives you a sense of what the adequate approach or its opposite strength would be. So an evaluation can be looked at both in terms of its adequacies and the problems with its reliability. So the 4 main dimensions are these up here. The first one, management of professional relationships, and I'll define these all in a minute. The second is data adequacy, technique adequacy, and the fourth is reasoning adequacy. So that's the kind of rubric that we'll be using to present to you some of the sins that we've selected. And that first component we're going to just shorten and call case management sins. Has the evaluator cautiously managed the relationships with the litigants' children, collaterals, attorneys, and court toward the goal of a competent, sufficiently focused, conflict-free, and cautious process? In short, how did the evaluator do at relating to those involved in the case? Okay, so this involves everything from, does the evaluator appear to have sufficient competency, to what was their attitude toward the litigants and the child as they did the evaluation. It includes basic things like file management, adequacy of record keeping, and things like whether the report was written in a way that is professionally respectable and suggests reliability. So the first sin I'm going to talk about is inadequate transparency, and in particular inadequate transparency about data. So here the evaluator chooses to not include one or more of the following: important data that formed a basis for the inferences, but they don't put it in the report; data that argue against those inferences, which is an interesting one, and I find this relatively frequently, where you get a look at the original forensic file and you find out that select pieces of data were left out that, had they been put in the report, would have possibly opened the person up to a line of attack on their ultimate conclusions, or data that might be viewed as reliable by the court on its face, but the evaluator for some reason decides to sift it out. So what does this actually look like? You've got the evaluator does not fully make clear in the report what documents were reviewed, the test results, for example, observations related to certain conclusions, the specifics of collateral comments, or another thing that you see sometimes is excessively brief summaries of interviews, where you just know that there's a lot of meat being left out, and we've got a decision to make, right? We've got a decision to make about efficiency and about not being overwhelming in the size of our reports. However, sifting is sifting, and sometimes it goes to an extreme where we don't get enough of what really was said to the evaluator, what they observed. Some forensic reports are heavy on conclusions but light on supporting facts, and then others fail to mention information that, had it been mentioned, might be interpreted differently by others. And we have to remember what the foundational kind of jurisprudence principle is here, which is the right on the part of litigants and children to be able to adequately inspect the data that may be being used to redirect the trajectory of their lives. That's the whole point, one of the points of adequate discovery. And if we don't put important things in our report that we actually heard or observed, it makes it much, much harder for a reasonable litigant to try to defend themselves against our report, for example. So here's a case that I was involved with, and that gives you a sense of how this can play out. This is an extreme. It's a 10-page report. This is a real quote, quote, "A battery of psychological tests were administered and both parties were found to be stable, although the mother did appear to be somewhat suspicious on one of the instruments." Nowhere are we told what the instruments were. Okay. A thick stack of documents, easily 10 inches thick, was reviewed. Okay. There's no catalog of the documents in the report. In this case, the mother vehemently denied chucking a glass at her husband's head. And when you look at the notes in the case, she actually gave a very detailed and cogent presentation of how, A, this didn't happen, and B, why it couldn't have happened, and the evaluator omitted that from their final report to the court. And again, we have to remember how many of these cases settle without the parties ever getting to really look at what was being used against them underneath the evaluation. So it can be kind of a scary thing. Now, look, we're in the same area of case management, and this next sin is one of the ones that's my favorite, and the fancy term is intense disaffiliation, or yuck. Okay, this is the yuck response. Indications that the mental health professional had a strikingly negative emotional response to one of the litigants that may have interfered with objectivity. You're nodding your head, you know kind of what I'm talking about. What does this one look like? Negative adjectives are used to describe a litigant with a frequency or an implied severity that just doesn't seem to fit the person, or that suggests the evaluator was very fixated on one parent's weaknesses. Okay? You might see an evaluator putting in a lot of energy as you read the report. You can feel the energy coming at you, a lot of energy into criticizing a particular parent or disagreeing with their assertions to a degree that seems extreme. Now, why should we care about this? A hallmark of effective forensic work is the even-handed and fair-minded interaction with those that are being evaluated. And some litigants evoke, no surprise, we've all experienced this, negative emotional responses, the yuck response, or transference reactions in the evaluator fueled by their physical appearance, maybe poor social skills, ineptitude, or, and this is an important one, striking dissimilarity between their worldview and the evaluators. Okay? And these feelings can cause very severe distortion in the evaluation process. Now, the case example I'm going to offer you here is a very interesting one. The mother was an attractive media psychologist of some note in the western third of this country. Okay? Father was a scruffy, disorganized attorney who worked in a poor section of town, and the father was questioning the quality of the mother's character to the evaluator. All right, so you see the setup, you see how these are very different people. Okay? Now, the evaluating psychologist chooses to spontaneously show up at the dad's home to do a home visit. No announcement ahead of time. The dad's in his bathrobe. Father is somewhat frazzled by this approach. And we see in his report, I watched as the father stayed focused on making his toddler's food while answering texts. And here we go with italics. The child was seeking my attention, not his, which astounded me. Underline, underline, underline. Exclamation point, exclamation point, exclamation point. All right? Do you see how we've already lost our way? You can't miss it, and you can't make this stuff up. This is amazing to me. All right? So there's one of the things it does, even if you look at that and you say, that's just from another planet, it damages our profession because we don't look like we're capable of sufficient objectivity in these cases. Continuing with the same case, the father seemed tense around me. I can only imagine, underline, underline. You can just see his pencil point breaking, underline, underline, how his son felt in this emotional environment. And then I learned that the father and son had been at the father's friend's home for the weekend and had actually just arrived at the home, underline, 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 prior to my arrival. Father obviously doesn't think about his son's emotional needs well. Nursery school starts at 9 a.m., underline, underline, and his son has only had an hour to settle into the home before having to dress for school. Now, here's my favorite part. In the conclusion section we find, the father has had several attorney positions over the years and has never risen above doing part-time, low-pay work. This raises the likelihood he has problems with interpersonal conflict in work settings, okay? The greatest testimonial to the mother's fine and model personality is the fact that she survived and thrived through a bachelor's, a master's, and then a rigorous doctoral program in clinical psychology. Such training is far more demanding than a 3-year law degree. So they had that part right. Other than that. So again, you can see. Now, remember, we're looking at, obviously, we're laughing, we're looking at the extreme. The lesson here, though, is that imagine examples that are far less extreme, but in a much more subtle way. You have the evaluator's status of being enamored with one party and responding with a yuck to the other, serving as a filter for how the data is then organized and gathered. All right. So let's talk about data sins. Did the evaluator? Excuse me. Let me go back here. Here we go. Got it. Did the evaluator gather a data set characterized by sufficient breadth, relevance, and balance to form a foundation for the kinds of opinions sought by the court and or the attorneys? Okay, so here we're looking at what was the sample that was taken. Was it an adequate sample? Was it a skewed sample? There's lots of possibilities for how things can go wrong in this particular area. I'm going to pick a sin labeled insufficient exploration of parenting, all right? And this basically involves a failure to adequately explore history, skills, and attitudes relevant to parenting. Now, this sounds very basic, but it'll be interesting for you to see your reaction to how it can play out in some real cases. But what's it look like? The report, for example, might seldom mention parenting-related concepts like capacity to communicate with the child, role modeling, disciplinary philosophy, et cetera. You don't see much of that in the report. There's a heavy emphasis on things that may only be indirectly related to parenting, like mental health status, diagnosis, dating and marriage history. And there's just or you might see an absence or a cursory approach to the parent-child observation part of the assessment. So why should we care about this? The evaluation of relative parenting assets and liabilities is the reason we're getting together in the first place. What skills and attitudes relevant to raising the child in question does each parent bring to the table? What parenting tools do they have in their toolbox? I mean, basically, to a large extent, what we do is kind of a parenting toolbox assessment. Evaluators tend, at least in those that I've reviewed in different parts of the country, to default to areas of assessment that they feel most at home with. So somebody that comes from a substance abuse treatment background will often have a heftier alcohol and drug section. Somebody that comes from a marital therapy background may overemphasize marital history to the detriment of parenting issues. And here's a case example. Two parents in their mid-30s. They had two elementary school boys, one of them that had special needs and tended to get oppositional at home. God bless you. Father alleged was alleged to be permissive to the point of enabling the child's acting out, and the mother was alleged to be volatile with the boys to the point of being regularly frightening for them, having a very harsh approach. The report arrives to the court. It is 52 pages long, and it has 20 pages on how they met, what they did on their first date, how he proposed, what they had in common, and when they first felt something was wrong. Okay? Now, again, those things may not be entirely irrelevant, but it's the fact that so much space is being taken up to the detriment of doing what we're really getting together to do. This case continues. There's a whole page on sex, the gist. She apparently liked light bondage, which was a turnoff for him. She would want him to pursue her sexually, yet he would distance, a dance they did for years. She made movies of their sex, which he refused to watch. She thought he had low T and dragged him to 3 specialists. Okay? Who are they as parents? Why is this even in the report? There's no allegations about somehow their sexual life somehow getting the kids involved or affecting them. Virtually nothing substantive about the father's permissiveness or the mother's volatility in the report. And lo and behold, the evaluator had been a sex therapist. And that's what she emphasized in the work that she did. All right, the next set of sins we're going to refer to as technique sins, and basically this is with respect to whether or not the evaluator executed the assessment technique in a manner that is viewed by his or her field as reliable and valid. So that last set we were looking at, what was the data that they gathered? This is about, did the evaluator apply or execute the art and science of their discipline in a way that is in line with the best literature we have on what we should and shouldn't be doing in this kind of an assessment. So the sin I'm going to pick in this area is no cross-checking, failure to give each litigant parent an opportunity to respond to or give his or her version of each major allegation leveled by the other parent. Okay, failure to give them a chance to respond. So now what does this look like? Here you've got basically, you look at the report or the session notes, and you see that the evaluator appears to have not given them this chance to respond to what's being said about them by the other parent. You might see a listing of allegations, but no response from the other side. And why should we care at all about this? Some evaluators use a kind of clairvoyant approach to arriving at their inferences. Okay, they interview mother and they hear critical or worrisome things about dad. They interview the father and they hear critical or worrisome things about mother, and then following this data collection, they don't ever give an opportunity to respond to the allegations that are being made by the other party, as I said. This approach is sometimes used with the good intention of not making things worse in a family by avoiding the heightening of tensions. Some evaluators are really uncomfortable with conflict, and this is not a good field to be in if you are, or we got to get therapy about that issue, right? Some evaluators don't want to experience that setting of, for example, having them in the same room, which I know David and I at least are in line about. This should be a central aspect of most of these assessments. They're not comfortable confronting people with things that are going to make it difficult. I mean, when I get to that last session in my process where I'm going to go through all of the allegations, I warn them ahead of time, this is not going to be comfortable for you, buckle up, but we've got to do it, and in the end it's going to be good for the assessment at least. It represents a serious disservice to the parents and the children, because otherwise, when we fail to give people an opportunity to respond to allegations, we're not doing an empirically sound approach to assessment. So, this is again a real case. The mother alleges that the father was intimidating, regularly threatened her. There was occasional violence, and it had been manifesting over the last 6 years. She states that some of this frightening behavior happened in front of the child. The evaluator also hears from the husband that the mother had on occasion thrown things at him and threatened to jump off a balcony in front of the child when she got angry one time. Now, neither party gets asked about what the other person has said. So there's no information confirming violence and none confirming or disconfirming it from the collaterals. The evaluator gets mom's data, gets dad's data, goes, something happens between their head, and they say, they conclude that dad appears to be a coercive control batterer and he should be supervised, okay, having never heard his side of the allegations against him. All right, getting close to wrapping up here, we're going to talk about reasoning sins, and this involves whether or not the evaluator reasoned about the data they gathered in a manner that was sufficiently based in the empirical literature of their discipline, internally consistent, logical, objective, and marked by appropriate professional restraint, which is where I think we often go wrong in our field, and you're not going to be surprised to hear me saying that, I know. So let's look at this sin underneath reasoning. I picked the sin of subjective parenting judgment. Inferences appear based in subjective parenting values held by the evaluator rather than on empirically confirmed information. Okay, so the evaluator's head is kind of getting in the way here. What's it look like? You look at the inferences, usually at the end of the evaluation. Sometimes people put them at the beginning, and they read as if they're more an expression of the evaluator's philosophy on life. Children should not sleep with their parents. Overscheduling of children is bad. Underscheduling of children is good. Okay? And each of these things, these little examples I've given here, the evaluator could easily go out to the empirical literature that we have on these topics and get some information that would be useful or that would actually pull the pins out of the position they're taking, but sometimes they fail to do so. Why do we care about this? We are not charged with imposing our personal subjective preferences on the data that we gather, although sometimes it's difficult to avoid that. We're charged with interpreting the data through the lens of the accumulated objective knowledge of our discipline, not through the lenses that hold our subjective values about what's good and bad for children. Offering opinions infused with our personal values about parenting is akin to running out on the street and grabbing a grandmother, bringing her in and saying, what do you think we should do? I mean, the bottom line is that we don't have anything beyond our personal philosophies to bring to the assessment of the family, then we should be keeping our mouths closed, would be my position at least. We are first and foremost representatives of the library of our discipline. So, case example, a red flag could be raised from these comments, which are real comments. Quote, this child plays violin every morning at 5 a.m. She then does swimming before school, followed by soccer at night. Children should not be scheduled this heavily and need more free time, underline, exclamation point. All right? Now, some of us, if I polled you, would raise your hand and say you agree about that. Others would say, well, wait a minute, she could be the next violin virtuoso because her parents were so demanding. We're not going to get into that now. The point is, do we have anything in our discipline library that supports the notion that this should be viewed as a risky circumstance for children? So, okay, what I'm going to do is I'm going to turn things over to David and pass the baton here.
Okay. I put my email address up there so that if you want to contact me for a couple of things that I'm going to be referring to as we go along, you'll be able to do so. The first set of slides, I'm going to be talking basically about 6 different errors, some of which fit very comfortably into Jeff's classification scheme, some of which perhaps don't fit quite as comfortably. And I'll also point out, since Jeff made this comment about humiliation, that of the 6 errors that I'm going to be discussing, 3 of them were made by evaluators whom I know personally, have good relationships with, and I only point that out because though it is not common, it ought to be possible for us to look at each other's work, register criticisms where criticism is warranted, and still maintain relationships with one another. Okay, so one of my favorites relates to drawing. I will point out before I even start that when I talk about drawings in a very disparaging manner, I'm not talking about drawings as a facilitative mechanism. If in order to engage a child, you want to do drawings, you want to play with the kid, that's one thing. I'm talking about drawings as X-rays. And what I mean by that is a radiologist doesn't need you in the room to interpret your X-ray. And there are some psychologists, social workers, others who do evaluations, who take drawings the same way a radiologist treats X-rays. Here, kid, here's a piece of paper, do a drawing of whatever. They then take the drawing. They don't ask a single question. They don't make a single comment. They take the drawing, thanks, kid. They put it in the file. And when it comes time to sit down and do the report, they pull out the drawing and say to themselves, let me see, what does this tell me about this kid's family, and so on. And this, to me, is mind-boggling. So, this is from an actual case. Here's the drawing. Here's the interpretation. What we see in this drawing is known as floating. It's clear from Sally's positioning of her father, floating, that in her eyes he has emotionally left the family. Now, first of all, has the dog also emotionally left the family? Question number 2. Why is Sally holding on to Dad? Well, the answer, of course, is to keep him from leaving the family, I guess. But if you were to discuss the drawing with the kid, you might be able to talk about these things. And finally, who knows where the baseline is? Maybe Mom and the kid are sinking. Why do we assume that it's Dad and the dog who are floating? And
That's good.
I'll point out to you, so that no one will leave this room feeling terribly guilty, we're all laughing, and it is funny, except you do have to, at some point, step back and remind yourself that some family is being affected by this person's input to the court. When you contemplate that, somehow the humor disappears. On a situation like today, it's fine to laugh about it. Now, the other thing is, if you've ever attended, and I hope some of you or many of you have, a presentation by Jay Flynn's, you are filled with information about the deficiencies in our various instruments. Do not walk away with the message that because so many of the instruments out there are deficient, you should just kind of come up with one of your own. But every once in a while, somebody comes up with what they think is a really great idea. And in this case, that, to be fair to the evaluator, that's not what she calls it, that's what I call it. But that's what it is. This is a way of measuring attachment. Knocks on the door as a measure of attachment. All of what I will read to you, by the way, comes right out of a deposition transcript. Each parent comes to the office with the child. When the mother comes with the child, part of the time is spent alone with the child. Part of the time is spent observing the mother-child interaction. And part of the time is spent alone with the mother. And the attorney's questions, which follow, relate to that portion of the session during which the evaluator met with the mother. The child in this case is 4 years old. Based on her recollection, the number of knocks was not recorded, which I'll get back to in a moment. So it's based on her recollection that a 4-year-old child knocked more while the evaluator was with the child's mother. The evaluator has concluded that the child is more attached to the mother than she is from the father. And here's the deposition stuff. Question. While you were interviewing mother and child was in your waiting room, was child able to hear your interaction with her mother? No, the door was shut and it was locked. She was locked in a little waiting room that I have. And I always make certain that the child is comfortable. I don't just suddenly say, you're staying here and we're going inside. I mean, hey, I'm a mental health professional. I finesse it so the child will be excited to play with the toys that are there. And I let them know they can knock on the door if they need to. So basically, number one, she's come up with this wonderful new system, and the system is you lock the kid in the room, and you see how often the kid knocks on the door. I'd say that's questionable. But let's assume for the moment that you really believe this is an incredibly good way to do this. If you believe that, shouldn't you at least keep count of the number of knocks? And she acknowledges she didn't even count. It's just her impression that the kid knocked more when she was with Mom than she was with Dad. Now, the next one, which I refer to as the investigative paradigm on steroids, there are obviously times when we feel it would be useful to really know how Mom and Dad interact, how Mom and the kid interact, how Dad and the kid interact. But we don't drop mics into people's homes. Well, some evaluator thought that he could do something pretty similar to that. He wanted information regarding the parent-child interactions, and he came up with this ingenious plan. 12-year-old child carries a cell phone with her. With the consent of the child, and we all know what that's worth, the evaluator uses the child's phone and dials his own number on her phone, and then when the child leaves She is asked to leave her phone on as she drives home with her father so that he can listen in on their conversation in the car. Now, I point out that in the model standards, 4.2, for psychologists in the Ethics Code, 3.04, we are reminded that we are to avoid harm where harm is avoidable, and we are to take steps to minimize harm where harm is foreseeable but not totally avoidable. The evaluative process is harmful, inherently so, and we need to appreciate that. We are intruding into people's lives. We are basically telling them that during this period of your life, your privacy rights are, to say the least, limited, almost absent. Depends upon what state you're in, and that'll come up in one of my other set of slides. Some states are more intrusive than others in terms of what they demand of people. But certainly one of the things that we need to consider is what happens to this child's relationship with her father when the father discovers that the child colluded with the evaluator to spy on this conversation. And presumably, if the evaluator learns anything interesting in this conversation, he will allude to it in his report, and then Dad is likely to be a little upset with his 12-year-old daughter for having participated in this. So despite the fact that we need to consider that there is an investigative component to our work, this is really kind of going over the top. Now, there is a decision in a case by the name of Frankel. I have it if people want it, and when we get done, you'll see why you might want it. I will point out that the evaluator in the decision is not named, so if any of you feel more comfortable reading about somebody's errors without knowing exactly who it is, you can read it in more comfort. So this relates to the flip side of what Jeff talked about when he talked about disaffiliation. This relates, though there's some of this here, this relates in large part to taking a liking to one of the litigants, and as a result, it kind of clouds your objectivity. So on cross-examination, it was revealed that Dr. X's opinions regarding the anticipated step-parent were formed without receiving and reviewing the notes of a treating therapist. This is New York State. New York State has very strong case law that says that when you become involved in custody litigation, your mental and emotional health are an element of what the court needs to look at, and therefore, in a sense, you have placed before the court the issue of your mental emotional health. Therefore, you waive privilege. And so in New York, it is virtually automatic that any form of treatment records are to be considered by a custody evaluator, and here custody evaluator is specifically faulted for not looking at that information. Additionally, her opinions were formed without the knowledge that Dr. Z, upon whose opinion she relied in part, is not licensed in New York and received her degree from an online university. This is important because many people don't recognize that when we get collateral source information from professionals, we are responsible for having some knowledge of the credentials, the background, and so on of the professionals from whom we're getting collateral source information. Dr. X refused to review and consider a submission from the other parent's attorneys, which included an affidavit from the ex-spouse of the anticipated step-parent containing information about the anticipated step-parent's mental health and stability. As a general rule, when one attorney says to you, I want you to look at this, and assuming you're using appropriate methodology, which means the other attorney gets a copy of whatever it is, the other attorney gets the letter that says, I want you to look at this, You give the other attorney time to object if he or she feels an objection is warranted. If there's no objection, when someone says, I want you to look at this, you look at it. You have the authority as an evaluator to give it any weight that you believe it should be attached to it, which including 0. But you cannot decide to give 0 weight to something without even having looked at it. So she was faulted for that. And then the conclusion by the court is the conduct described in what I refer to as the previous slides appears incongruent with Dr. X's role as a neutral evaluator. So when you add it all up, what the court is saying, and the court ultimately, by the way, completely disregarded the evaluator's report. What the court is saying is, I can't rely upon this person's input because this person lost her neutrality. Just to give you a summary of why I think it's an interesting decision. 28-page decision, 10 pages to historical information, 5 to the legal bases for the court's order, 2 pages to actually describing the order, 4 pages to a description of the testimony, and 7 pages of a 28-page decision outlining 17 specific criticisms of the evaluator's work. And I should also point out that the judge in this case was the person who appointed the evaluator, and it was an evaluator that the judge had used many times before. Now, the next thing deals with what I call the focus issue. What are we focused on? And in a very brief piece that I wrote for, I guess what's best described as a newsletter, The Matrimonial Strategist, simply entitled When Custody Evaluators Lose Focus, I talked about situations in which the evaluators look at things other than the best interests of the child. And one of the things that I find most common when this occurs is that the evaluator ends up focusing on the evaluator's conception of fairness to the parents. And in this next case, an evaluator actually ignores the law of the state in which he operates and actually says so in his report. State of New Jersey, 14 factors are to be considered in the development of parenting plans. Of those, employment responsibility is one. Mr. and Mrs. Worker are involved in custody litigation. Though both parents are employed, Mr. Worker works in a family-owned business, and the other members of the family afford him great flexibility with regard to such matters as his arrival and departure times. So that this is a guy who, because he works in a family business, can show up late for work, leave work early, take off in the middle of the day if kids in a school play, whatever it may be. Mrs. Worker works a stereotypical punch-the-time clock type of job. It is indisputable that Mr. Worker is available to the children at times when Mrs. Worker is not. In her discussions with the evaluator, Mrs. Worker advances the position that consideration by the evaluator of the employment responsibilities criterion would place her at an unfair disadvantage. And so in his report, the evaluator expresses his support for her perspective and makes it known that this particular criterion will not be considered by him. So he's informing a court, I know there are 14 things I'm supposed to be looking at. I'm only going to be looking at 13. I'm not going to be looking at one of them because to look at that particular criterion really wouldn't be fair to mom. At the risk of sounding callous, we're not supposed to be worried about fairness to mom or fairness to dad. We're supposed to be focused on the best interest of the child. And sad past as mitigation. This is one of my favorites that I wrap up with. Mr. and Mrs. Jones have 2 children. Mr. and Mrs. Smith have 3. Mr. Jones and Mrs. Smith commence an atypically overt adulterous relationship which continues unabated through the course of the custody evaluation being conducted in connection with the Joneses' divorce. And when I say overt, I really mean in your face. I don't mean they had sexual relations on the street, but they basically went places together as a couple when the family hadn't even officially been divorced yet, and so on. In order to understand Mr. Jones's behavior, it must be seen in a broader perspective. Throughout his life, Mr. Jones has borne the burden of trying to meet expectations communicated to him by his parents. At 45, it was long past time for him to individuate and break free of parental control. His adulterous relationship was undoubtedly his way of letting his parents know that he's now his own person. So you reach a point in your life where it's important emotionally to say to your parents, listen, you have your values, I have my values, I have to live by my values, and I've decided that the best way to make this point at the age of 45, when I have kids and the other person has kids, is to have this in everybody's face adulterous relationship. So, the one thing I have no idea what's going on here. The one thing I will say before I relinquish the mic to Tim is I already, before I even started, got asked some questions about, well, these are the ones that are most flagrant. What are the ones that you feel are most common? And by the way, there's some overlap. But I'll just run down a quick list. One of them is loss of focus. You forget what it is you're supposed to be concentrating on. In assessment area, there are people who use instruments that are indisputably unreliable. Either unreliable in the sense that there is insufficient or zero interjudge reliability, as is the case with drawings. Somebody would look at the same drawing and arrive at a different interpretation. Or poor test-retest reliability, that you're testing something which is transitory, which may be specifically related to the stresses of the situation, and which doesn't give you information that enables you to engage in long-term planning. Invalid in the sense that it's measuring something that's just not relevant to the issue. The most common example, in my view, is routine IQ testing of parents. I'm not suggesting that it's never something that it might be wise to do, but there's no indication at all that more intelligent parents are better parents or anything else of that sort. There's no documented link between IQ and parenting ability. So why do some people just routinely give IQ tests? What I call the stenographic method of note-taking, where you have a set of questions, you ask your questions, you write down the answers, and at no point do you engage your brain. You hear answers that demand follow-up, and you don't even think to ask the follow-up questions. My favorite example is an evaluator asks a woman with 3 children to describe her 3 children, and the woman says, they're real firecrackers. That's all she says. That's what the evaluator writes down. And at no point does the evaluator ask for a little bit more. 3 children in that many words, that's the answer to the question. On to the next question. Then Jeff made an indirect reference to this when he talked about not checking things out. I refer to this as the assessing credibility issue. We really have among us a disturbing number of professionals who believe that we can assess credibility in face-to-face interactions. I can tell who's BSing me and who is leveling with me. And so I don't need to check so many collateral sources. I don't need to do this or I don't need to do that because I can figure out, I'm a professional, who's telling the truth here. And what disturbs me, and Jeff also in his presentation made reference to the professional literature, is that there is a tremendous amount of material in our professional literature that tells us that we are ineffective as human lie detectors, that we are no more efficient at it than anybody else. And we really need to keep that in mind. And that, of course, is tied with another thing, which is just inadequate use of collaterals. And then the last one on my list of just common ones is, as I said, kind of the opposite of what Jeff alluded to, that you develop a liking for someone, an affiliation with someone, and sometimes it's simply based upon the fact that that person seems to have the same perspective on various issues that you do, and you find that person likable, and that affects where you go with the evaluation, what you do, what you look into, what you fail to look into, and so on. Okay.
Yep, got it. Thank you. Okay, good morning. I think they asked me onto this program to break up the monotony of responsible discourse. And I'll try. I think many of the mistakes, the errors, the sins, however you'd like to refer to them, that we're discussing relate back to some basic precursor problems that very often, if brought into focus, would put some perspective to the evaluation process. I think evaluators very often lose sight of the nature, the scope, and the limitations of the discipline of psychology. And from that lack of focus, a lot of these other errors flow. Psychology in any university Psych 101 course book, page 1, you're going to find either verbatim or very close to this statement, that psychology is the scientific study of behavior and mental processes. And if you take out the word scientific, you no longer have psychology, you have philosophy. And there's nothing wrong with philosophical speculation, but we don't allow that from the witness stand. The fact that you're allowed put on the witness stand is because of certain defined rules that your discipline hopefully meets that allow expert testimony to be given. Very good book, by the way, especially for the lawyers in the room to get some insight into critical thinking about the psychology discipline, is this one, How to Think Straight About Psychology. And he talks about the fact the only coherence that psychology as a discipline has lies in its commitment to science and the scientific method. He said the only two things that justify the existence of psychology as apart from philosophy is that it studies the range of human behavior with the techniques of science, and the knowledge of the profession is scientifically based. And that psychology gives two guarantees to the public. Right? One, the conclusions that psychologists express about behavior will be produced from scientific evidence. And also that no statements or conclusions will be expressed that are not derived from scientific evidence that was derived from tested scientific methods. That is the core value of the discipline of psychology, to ensure the reliability of the statements that psychologists make. In the year 2000, a view from the bench, a judge in California wrote an open letter to the psychology profession based on his observations in seeing the testimony. Your profession has strong roots as a discipline with a foundation in the scientific method. The problem is that some of you have stopped using it. And many of the mistakes and errors that David and Jeff have talked about, and some that I'll highlight shortly, flow from the fact that I think too often evaluators get out there, they're struggling to make this discipline accomplish the missions that are assigned, instead of asking, does this mission really fully fall within the ambit of my discipline? The best interest of the child, that ultimate, final, decisive question, is not entirely a good fit with the psychology discipline, and to a very significant degree falls beyond the boundaries of the limitations of the field. because it's a legal concept, and because there's no matching empirically derived construct in the psychology field that matches this amorphous concept that the law is attempting to describe by using the term best interest of the child. Nowhere is it operationally defined, not either by the behavioral science field nor by law. It is laden with value judgments that have to be made that fall outside the boundaries of any professional discipline. Right? Outcome subjectivity, variable subjectivity. These are the problems that the law, in effect, dumps upon the evaluator in asking the evaluator to come up with the magic answers that are going to make the court's job easy. Okay? No defined outcome criterion. Best interest of the child, indeterminate, value-laden standard. Let's just do a little thought process here. Something happened on that. Outcome A, outcome B. Let's suspend reality for a moment and assume we can do something. We can perfectly predict that if we give the child to parent A, this will be the outcome for the child. Parent B, that will be the outcome. Right? If we give the child to parent A, the child is going to barely make it through high school. College will be out of the question. He will never hold a steady job. Right? But like Alfred E. Newman from Mad Magazine, he will never have a single moment of stress. He will be happy as a pig in slop. Me, worry, no. As long as I've got the remote and the Cheeto crumbs falling all over me, life is good. That's parent A. On the other hand, if we give the child to parent B, the child will perform at the highest possible academic level through undergraduate education, go on to postgraduate or professional education, and will go on to the top of his career with all of the professional and material success that goes with that. But of course, as some of us know, we'll pay a price for that. The occasional Xanax will be necessary to get us through the goddamn day, all right? And it all goes with the territory, all right? Here's the question. How many say, knowing those two possible outcomes, let's give the kid to parent A? How many say A? May I see your hands, please? May I see your hands? All right. How many say B? All right. And most of you are not voting. And I'll say this to you. I'm sure the ones who said parent A are mental health professionals, and the ones who said parent B are the lawyers who said, get those bucks, pop those pills. But now let's change it a little bit. How many of you said you go with outcome A? Let me see your hands again. All right? So you take that stress-free, carefree life in lieu of money. Let me just change the fact one little bit. Outcome A is the same. Outcome B, high success, only it's not money. He'll discover a cure for cancer that will wipe that disease from the face of the earth. How many of you who said outcome A was better would now say outcome B? All right, a couple. Here's the point of all of this. No matter how you voted, nobody's going to walk through that door with empirical research or law that's going to prove you wrong, because you exercised judgments on values. And every time a judge decides best interest, the judge is making value judgments, if not explicitly, certainly implicitly. Variable subjectivity. Some states, many states have statutes that delineate the factors. Other states, like New York, common law, you derive them from the case law. All kinds of factors to be considered. But nobody tells us how to weight them. All right? One factor, which parent best contributes to the intellectual development of the child? Another factor, which one better contributes to the emotional development? Two different factors. One is parent A and the other is parent B. Should one weigh more than the other? And if so, which one? Or should they be weighted equally? No guidance. So we wonder why evaluators are kind of floundering at times. They're trying in many ways to put a square peg into a round hole. One judge succinctly said, bottom line, what's in the child's best interest equals the judge's best guess. All right? A refreshing moment of judicial candor. So, all of that being said, to put this in perspective, under the law of evidence, what does the expert bring to the courtroom? All right? Under 702 Federal Rules of Evidence, in most states, enlightened states that have model evidence codes, statutory codes, pretty much pattern this, backward asinine states like New York that have no code, even our case law models this. The point is, experts are there because of expert knowledge, scientific knowledge, technical knowledge, or specialized knowledge. Those are the parameters that justify the expert being in the courtroom. Expert-based knowledge. That's the only thing that justifies that expert's presence in the witness stand. So, what's the structure of the expert opinion that the expert is bringing? This applies to any kind of expert in any kind of case. Right? It's a logical structure, is it not? You have to have at least one major premise, you need at least one minor premise, and you have to have a conclusion. The key, in terms of what we're discussing, is the major premise. Right? Minor premise is just the case-specific information. Minor premise data, the case data. What you got in the interviews, what you got when you did the testing, what you got when you did the interactive sessions, and so forth. But you have to make sense out of all of that based on your expert knowledge. Right? That is what distinguishes an expert opinion from non-expert opinion. It's the major premise. Right? If it's anything else, it's not an expert opinion. Right? If it's common sense, I've heard evaluators, I've heard experts say, when cornered on cross, well, what's your empirical basis for making that statement, doctor? What research can you cite in support of that? Well, it's my common sense. Get out of town, all right? You're not on the witness stand because the law assumes you to have common sense superior to the fact finder. You're there because you have uncommon knowledge, your expert knowledge. Pseudoscience, junk science. This is really the most dangerous because it looks like a duck, it walks like a duck, it quacks like a duck, and it turns out to be a goddamn kangaroo when you get down to it. Right? But it has the aura of science, and that makes it especially dangerous. The Daubert decision, which is applicable in most jurisdictions, not New York, thank you. We're still in Fry, screwing around with one criterion, refusing to consider others. Right? But Daubert says, we give experts latitude on the stand that we deny to every other person on the witness stand, and the basis for that is our assumption that the conclusions that they're expressing have a reliable basis in the knowledge of the discipline. Not his knowledge, not her knowledge, the knowledge of his or her discipline. From our good friend, Dr. Martindale, in the year 2001, wonderful article, and he states it very succinctly. The defining attribute of an expert opinion relates to the procedures that were employed in formulating the opinion and the body of knowledge that forms the foundation upon which those procedures were developed. If the accumulated knowledge of the expert discipline was not utilized, then what you're getting is a personal opinion. It just happens at that moment to be coming from the mouth of someone who has professional credentials. But it doesn't make it admissible. Ignoring the boundaries of the research. Turning this around a bit. I often do workshops exclusively for mental health for psychologists who are getting ready for their AFib and so forth. And I tell the optimal way as an evaluator to ensure that your inferences and your conclusions will qualify as expert opinions is to base them on the research of the discipline and provide references in your report to the articles upon which you are basing your conclusion. That is the best way to make sure that what you're saying is predicated on the knowledge of your discipline and constitutes an expert opinion. Right? Another problem, commenting on issues outside the knowledge base of the discipline. Earlier, David said, somebody asked him before, these may be some of the most outrageous, but what are the most common? Well, here's one of the most common, is going places you just shouldn't be going, all right? One evaluator puts in the report, seems to me that the child support level is a little low here and really that they should be made to pay more child support. Oh, really? Oh, really? From what course in your PhD training, doctor, did you derive that conclusion? All right? Or, I went to the home ground on one occasion, and there's a real problem with the electrical outlets there. All right, really, what course did you, those things may be true. They may be based on good faith, common sense, and so forth, but they're not expert opinions coming from a psychologist. We wouldn't call an electrician to the stand and ask them to interpret a Rorschach now, would we? Using techniques, making statements that the research has not yet established to be reliable and valid, or even worse, using techniques and making statements that the research has already repudiated. Anatomical dolls as an instrument for determining whether or not the child is sexually abused and who did it. All right? The research has repudiated that as an assessment instrument to answer those particular questions. All right? The family bed issue. I have heard, let me ask you this, how many of you have heard expressed in the courtroom, in custody cases, an evaluator on the witness stand fault one or the other of the parents, usually it's the mom in my experience I hear being faulted, for allowing this 3 or 4-year-old to sleep in the family bed? That's bad parenting, bad outcomes. All right? Have you heard that? How many have heard something like that? All right? How many have heard it at all recently? Yeah, still hearing it. All right? In the first instance, it was said before the research was done. All right? Before the research has been done, and you're asked that question, there's only one proper answer to give, and it's 3 words, the 3 hardest little words ever. I don't know. All right? I don't know, Judge. My discipline has not yet formulated an answer to that question. There should be no embarrassment in that. But worse, it's now being given still testimony recently, you're saying, where you're hearing the same thing, even though the research has been done, and it does not result in negative developmental outcomes for children. I think it might be helpful to the evaluator to think in terms of your metaphorical library of psychology, where all of the knowledge of your discipline is stored and readily available, not uniquely to you, but to your profession. All right? And your job is to tell the court what's in the library. All right? What's in the library, and how does that expert knowledge from that library apply to the case before that particular judge? And I think if you visualize your task in that fashion, it helps you stay out of trouble. Cavalier and idiosyncratic approaches, ignoring guidelines and parameters. Very, very common. You want another one that's common? May not be as sexy as some of the other ones we're talking about, but here it is. All right? AFCC, APA, ACAP, they've all published parameters, guidelines, model standards. All right? In my judgment, the AFCC is absolutely the best thing out there. It's the most current, it's the most comprehensive, it has an interdisciplinary orientation, it's detailed. But whatever, pick one. Pick one, and when you pick it, stay with it. All right? If you're using idiosyncratic approaches, you may even be jeopardizing admissibility. All right? What do I mean by that? Dr. Smith is on the stand. I've had this occur many times. Dr. Smith, were you guided in your methodology by AFCC model standards? No. APA, no. ACAP, no. You go through the other ones that are not quite as significant as these. Doctor, did you, in formulating the methodology that you applied in this case, rely upon any published guideline, protocol, or practice parameter. Well, no. I use my own. You use your own. And is this something that you pick? Or they may say, I picked and chose. I took some from one, some from column A, some from column B. So in effect, Dr. Smith, you applied the Dr. Smith methodology. Is that correct? Yes. One question, doctor. Have you ever published that methodology in the peer-reviewed literature of your profession? No. All right. One other question. If it's never been published, doctor, it's fair to say that it's never gained general acceptance within your professional community. Would that be correct? And in a Frye state, you have a very serious issue now with admissibility and striking of the testimony. And even in a Daubert state, general acceptance continues to be one of the criteria that a court may apply. Pick one. Don't go in there, seat of the pants, this is the way I do it. All right? Ignoring role boundaries. Another one that's very common and leads to some of the errors that we're going to mention here. The forensic role is different than any other role in psychology. All right? It's to investigate and report. Period. Okay? The evaluator's sole obligation is to investigate the case and report to the court. It is not to help the parents. It is not even to help the child, other than by meeting the obligations of the forensic role to report accurately, investigate thoroughly, and so forth. And I see time after time evaluators go off the rails because they want to help. They want to help. All right? Evaluator is not a therapist. Not a negotiator, not a mediator, not an arbitrator, and not a parenting coordinator, and not a junior judge. I say that because in one case, the doctor greeted the people at the first session of the evaluation by saying, "You're in my courtroom now." How's that for an examiner effect, all right? You're in my courtroom now. So, giving advice. Actual example from an actual case. The evaluation is underway. There have been a number of sessions, but it's not completed. And one day, mom has the kid wake up, and the kid says, "I'm not going to school," and pitches a massive fit. "I'm not going to school," and has a complete meltdown. Mom, not knowing any other mental health professional, called the evaluator and said, "So-and-so, my little boy won't go to school, he's melting down, and hear him screaming in the background. What do I do?" And the evaluator says, "Well, let me talk to him." All right? And now she intervenes and talks to the kid and then talks to mom and says, "This is the way you should do it," etc., etc. Big problem. All right, big problem with that. It's outside the forensic role, number one. Number two, from this point on, the evaluator is now interpreting data of which she is a part. All right? She has changed the matrix. She is now part of that matrix. You know? She'll never know how mom might have resolved that in the absence of her advice. All right? It also has a possible biasing effect. Suppose mom said, "I don't think you know what you're talking about. I'm not going to do that." All right? That might have some biasing effect going forward. Right? Offering parents suggestions as to how to settle the case. You know, I'll tell you at the end of this evaluation before I do a report, this is my proposal. And if you don't go along with this proposal, then, I file my report and the chips fall where they may. All right? Again, major problem. First of all, that's coercive. That's coercive. Those clients are sitting there, those litigants are saying, if I'm the one who says no, this doctor still has to write the report and I'll get crucified. Right? It's outside the role and it can distort the data. Possible biasing effect. One parent says, "Oh yeah, doctor, that's a wonderful proposal. You are the smartest doctor I've ever known." And the other one says, "I think you're full of crap." All right? That might have an effect on the evaluator. Hearsay reliance. 703, we don't have time to discuss it. This is a 2-hour discussion all by itself when we get into this. Hearsay reliance can threaten the admissibility of your report and your testimony if you make a mistake and rely upon the wrong kind of hearsay data. It can also affect the weight and reliability of your testimony, as was recently pointed out in a Court of Appeals decision in New York, which is our highest court. How screwed up is New York? What do we call our lowest court? The Supreme Court. And it can be reversed by 2 higher courts. Wonderful. But they point out that relying on hearsay is a weakness, not a strength. It becomes a problem. Right. Here's one from an actual case. Now, doctor, you told the court in your report that Jill told you that Jack's ex-wife's aunt told her that Jack's ex-wife had told the aunt that Jack had once shot a gun in the marital residence. Correct? All right. I mean, how many levels of hearsay are enough? And doctor, it's on cross-examination. Doctor, did you go back and talk to Jack's ex-wife to at least bring us down to 1 level of hearsay? No. All right. Did you go and talk to the aunt to get us down to just a couple? Well, no. All right. Did you ever even ask Jack? He was right there in the interview. You had another session with him. Didn't you at least turn to him and say, hey, Jack, what's up with this? Did you shoot a gun in the house? No, Mom told me that was good enough. You can't make it up. You can't make it up. Ignoring the appointment order. All right. Failure to abide by restrictions. All right. You have to read carefully each one in each case. All right? I've seen them where in one appointment order, the judge says, no psychological testing without further order of the court. I'm not saying you can't do it, doctor, but if you want to do it, you have to come back for permission. Never go back for permission, and they just did a battery of testing. Many judges today, or a significant enough number, put right in the appointment order, do not make a recommendation with respect to who should get custody. Give me a statement of risks and benefits based upon blah, 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 but don't give me that. And you see the report comes in, and they gave it anyway. And now the court has to say, do I strike the whole thing, assign a new evaluator, or do I play the mental gymnastic game and say, well, I'm striking it, and I'll pretend I never heard it. You know, that kind of game the law likes to play. You have to read everyone individually. They're not all cookie cutters anymore. The non sequitur, refusing to concede the obvious. Okay. Doctor recommended in favor of the father. All right. We had ample testimony in the case that Dad had alienated the kids, including tape-recorded evidence. Because I told the mom, when he starts up, because they were living in the same house, just have a tape recorder in your pocket, and when it starts up, turn it on. New York's a one-party state, it's perfectly legal. All right? We had a tape with the father calling the mother in effing C in front of the kids, and the kids chiming in unison with him, calling mom in effing C. And the evaluator still came in favor of Dad. So I put the hypothetical. Doctor, assuming that you had known at the time that you did the evaluation that he had called her an effing C, and the kids called her an effing C, might that have affected your opinion? And instead of just saying, yes, it might have, right, he says, I'm not in the business of assuming things I don't need to know to be true. Oh, really? Well, let's go back to the other 47 paragraphs of the report. But the point is, the judge now gets mad at him because he's supposed to assume it. If you're asked to assume things, you have to assume them unless there's an objection sustained against the question. All right? So finally, I get him pinned down where he's going to answer. You know, would that be? Because I can't answer it in that form. And so let me ask you this way: would it be for a child to hear dad call mom an FXC. And you see what he's doing by fighting me. I've now gotten to say FXC 70 more times to the judge's ear. All right? And now the final, would it be, let's ask you this, doctor, would a child hearing the father call the mother that be a happy, healthy, and wonderful childhood experience? And so the answer was, it would depend on the circumstance. Okay, Doc, I'm going to go way out on a limb here. Name one. All right? So don't fight the process. If you're asked to assume the facts, assume that. If you're asked a yes or no, answer yes or no. Or I can't answer yes or no. Don't try to make speeches. In other words, don't be a wise ass. Right? And that's a term of art. You can look it up in the Black's Law Dictionary or in your APA definition or in APA dictionary, and the definition is slightly different in each, but the picture next to the definition will always be the same. Okay. You know him, you don't need to read the definition. Misusing text. Selection without reference. We're running close on time, but I just want to get to one last point here. Non-standard administration. The MMPI manual says you give it in a quiet setting, free of disruption. If you don't have ideal settings, maybe you use a waiting room, but you make sure it's a quiet waiting room without a lot of traffic. You don't want any distractions. And it says that right in the manual. All right? My dog doesn't bite. And if you remember, this I'm about to tell you is a final. Jeff and David and I, in competition with the Darwin Awards, we have our own "you can't make this shit up" competition. Okay? And what you're about to hear is a final. All right? Remember one of the Pink Panther movies? Clouseau goes in, an old Swiss innkeeper, and there's a dog there. And he says to the Swiss innkeeper, "Is your dog bite?" And the Swiss innkeeper says, "No." So Clouseau reaches down to pet the dog. And he almost loses his arm. So now Clouseau says, "I thought you said your dog does not bite." And the innkeeper says, "That is not my dog." A few years ago, Jeff and I are doing a seminar up in Rochester. We have mostly lawyers, but a few evaluators in the audience. And one of the lawyers at the question period says, I had a case where my guy was given the MMPI and the evaluator stuck him into a room where the evaluator had his vicious dog chained in the corner, snarling and frothing and so forth, And our response was, yeah, that would be a problem. That could impact the reliability and the validity of the test outcome. But we hear stuff like that all the time. We take that with a grain of salt, right? Except at the break, that was the test. The evaluator comes up from the audience and says to Jeff and to me, he says, "That was my case. It was my dog, and he's not that vicious." So it actually happened. That's the MMPI. That's the MMPI in that particular case. You can't make this shit up, and that's what makes it such fun. Thank you.
Jeff and I would like to jointly apologize for having invited as our co-speaker someone who lacks the ability to get emotionally involved in his subject.
But it's so much more fun presenting with him on days he skips his medication.
Yeah.
It's just a lot more fun. So, all right, I guess we're almost out of time. I apologize. Questions from the floor? Go ahead, just talk nice and loudly.
Jeff didn't want it near the computer.
Go ahead.
I have problems with answering hypothetical questions. I mean, I don't have a psychologist. The answer for my profession is often, it depends.
Right, right. I'm going to let Tim take that question. One of the things to remember that helped me was that hypotheticals, to some extent, are a tool for judicial efficiency because of the order of the witnesses. Now let Tim take that over.
I understand the answer. It would depend on the circumstances, but would you have given it to that question? All right. The hypothetical is proper so long as the assumed facts in the hypothetical are facts in evidence. Okay? I can't just stand there and make stuff up. I have to predicate any hypothetical that I put to you upon facts in evidence, or I assure the court that I will put those facts in evidence by an offer of proof. And if I fail to do that later, then it would all get stricken out. But I understand an answer that I cannot answer it in that form. It would depend on a number of things. But not to a question like that, not to a fact issue of that nature.
Any other questions? Go ahead, ma'am.
Hi, the reports that you reviewed would only reflect for the interviewing process on mine. I'm just wondering, has it changed how you determine your interviewing process with families?
Yeah, I think it has. I mean, it's very helpful to go through the process of spotting where people have gone awry and reminding myself of ways in which I have in the past. It has changed my approach. It's made me much more self-aware. I mean, all of us know when you do an assessment, one of the things you want to be doing is have a constant reminder in your brain going on of yourself with your rear end in that witness chair and having to defend the nature of your data, how you collected it, and ultimately how you made that logical connection between the data and the ultimate conclusions. Yes, ma'am. Yep. I mean, I'll let my co-presenters, do you want to say something about it? What are our views of audio taping the whole forensic process? Do you want to take that, Dave?
Yeah. Do it. Jeff points out that part of what we learned through this is reflecting on our own work. I can say that almost everything that I teach other people to do, I did myself when I was doing evaluations. There was one exception that I acknowledge. I did not tape record. It wasn't common at the time. I don't know of anyone who did it. I think tape recording is an incredibly wise thing to do. There's only one problem, and the one problem is, and many of you are familiar with the case in which I was involved, if you screw up badly, then there it is on tape. But if you assume that you're doing your job well, tape recording, like any kind of records protect good practice. The other thing I would point out is that most of you know that with improvements in technology, you could have a pen in your pocket and tape record people. So there are going to be litigants who will tape record you, whether you know it or not. You might as well be tape recording yourself. With regard to the issue of distraction, since I mentioned the pen, I would point out that there's a difference between doing something surreptitiously and doing something unobtrusively. Surreptitiously means I don't tell you I'm recording. Unobtrusively means I tell you I'm recording, I remind you that I'm recording, but I have a system that isn't sitting there in your face in such a way that there's a constant reminder, a distraction, or whatever. But I really would like to see more people doing tape recording.
And just one other thing. And if you do record, then don't destroy the tapes. You have to...
Sorry I didn't mention that.
And even worse, don't selectively destroy the tapes, okay? And that happened recently in New York.
Okay, question front row.
Is there anything we can put in our agreements with respect to our clients not recording?
You could certainly put into an agreement that you expect that those being evaluated by you will not be recording, but there's no way to prevent it.
And if a person is going to do it, the fact that they signed something is not going to stop them from doing it. And if, in fact, they have on tape some mistake that you made that they feel is pertinent, whether a judge cares about what was in your agreement or not is going to be up to an individual judge.
Yeah. They
Some
might still
might
admit
care,
it.
some might not.
They might still admit it as
Yeah.
evidence. So, yeah, one more question, then we're going to quit. Yes, sir.
With regard to what you said about questioning allegations,
Yep.
and as your kids also report.
Right. Let me interrupt you, because I think there's probably going to be differences in the room about how to handle that. I know from my perspective, with certain exceptions, I would not confront a parent with specific things that their child had said. I make clear to kids right up front that what you say to me, with certain exceptions, and I define those for them, I am not going to go down the hall and tell mommy and daddy. I also make it clear to them, however, that the report and its contents may well be read by mommy and daddy and by people outside the family. I can't protect you in that way, and I tell them that up front. So, folks, we have to stop. Our emails are at the beginning of each of our presentations. We'll be hearing confessions up here if you want to come on up. And thank you.